Good morning. So courts are central sites for those who turn to the legal system in matters of family violence. To illustrate how our courts are and could be responding to family violence cases, I want to work through an example with you based on a real case. So L has a young child, M. At one point, L was unable to care for M, so a parenting order was put in place to give K, L's parent and M's grandparents, sole custody. Once L was able to care for M again, the order was varied to give L day-to-day care of M and to give K contact with M on alternate weekends. This all worked well for a time. J, L's sibling and K's child, then moved in with K, the grandparent. One weekend, while K was looking after M, J became physically abusive to both K and M. When L picked M up, J was also verbally abusive to L. L is now worried about M being in K's care with J being around at the address. L wants to complain to police about the abuse and seek a family violence intervention order against J. Now, at a very high level, the traditional court response in this type of case would involve engaging with multiple courts, jurisdictions, and lawyers. L would have to go to the Federal Family Court of Australia to vary the parenting order. K, L, and M might all have to give evidence at a criminal trial against J in the Magistrates' Court. L would also separately have to apply to the civil list in the Magistrates' Court for an intervention order, or police might apply on their behalf. And possibly the Children's Court might also be engaged if there are child protection concerns. Practically, this means the cost of multiple lawyers and proceedings, L having to get childcare for M while they attend court, time off work, etc. And essentially the whole matter is broken off into different proceedings and different courts without necessarily understanding the whole family unit or dynamics. The traditional court response would also go through a normal case management process, so it wouldn't be prioritised for efficiency. There could be safety issues when all of the parties attend court. They might see J in the lobby. There are no separate waiting areas. They might all have to give evidence in the proceedings with no access, which can cause secondary victimisation if there are no remote witness facilities available. And there are also potential for the child protection proceedings to remove M from their care. Now, family violence courts were created as a direct response to these and other concerns with the traditional court approach and aim to provide a specialised, therapeutic and trauma-informed response in family violence cases. In theory, they operate to bring everything together under one court with dedicated courtrooms, have expedited case management so that family violence matters progress quickly for all involved, have increased safety mechanisms such as safe waiting areas and procedural rules that keep vulnerable people like M, the child, out of the courtroom, specialised training for judges and lawyers and everyone involved in the process, and access to integrated support services to provide wraparound support to both J as a perpetrator and to the family. So at a time when specialisation and therapeutic responses are increasingly being looked to within the legal system, my research seeks to understand how family violence courts balance these specialised purposes as against the constraints of their jurisdiction and the adversarial legal setting in which they operate. Thank you very much.